Now turn to the last case on this morning's docket. It is case number 109712 in the matter of Michael Clay Schnitger.
May it please the court, I'm Alexander M. Walczak, Deputy Disciplinary Administrator. With the court's permission, I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. A panel hearing convened on March the 8th, 2013 on the complaint against the respondent. Briefly, the nature of the complaint was that the respondent wrongfully and intentionally withheld from his law partner about $176,000 from his partner, and that the conduct occurred, or the amount of money taken, occurred repeatedly over a 3-year period. He used the money to cover personal expenses. There was no medical or other issues involved in the case. He just took the money. Additionally, during the time of the present misconduct in the case, the respondent was on attorney diversion for an unrelated matter. In this case, when confronted, the respondent eventually admitted to the taking or withholding of the money, and he paid back about $77,000 to his law partner.
That was an agreed amount.
That was an agreed amount between the two. Yes, Your Honor.
So it's not, okay.
The way it was, apparently both attorneys, as legal fees came in, they put it into one pot. And from that pot, they paid their expenses for their overhead, etc. And then from there, depending on what they brought into the pot, they took that money out as their draw. At the panel hearing...
Let me ask another question. Do you think it's fair then to look at this as a $77,000 value to the dishonest conduct?
The respondent's law partner was satisfied that that was an equitable amount of repayment. Yes. At the panel hearing, the respondent stipulated to the misconduct, and he stipulated to the rule violations, and the rule violations was 8.4b, commission of a criminal act reflecting dishonesty, lack of truthfulness and fitness, and 8.4c, conduct involving dishonesty when he repeatedly, intentionally to deposit the money into his personal account.
I'm curious, and I'm kind of jumping in here,
Sure.
But you characterize this as withholding money. This isn't withholding money. This is a pattern over 3 years in which he stole at least $77,000 and maybe and probably more. And I'm curious as to why your position is indefinite suspension, and I know you're probably getting to that, but I'll jump to it. When, if this had been prosecuted, we'd be here with a felony theft and perhaps a theft of over $100,000, which puts it at a level 5 or something like that. It's a super theft. And we would be automatically looking at disbarment, and that would be your position. So what's different about this, and why aren't we considering it that?
At the panel hearing, everybody, the respondent, his law partner, everyone recognized, and the hearing panel recognized, that if it was tried criminally, it was equivalent to felony theft.
And conviction, boom, you're here automatically within a week telling us to disbar this man.
You're correct, Your Honor. And at the panel hearing, and the hearing panel says that same thing in their final hearing report, I recognize that generally, and in following the ABA standards as appropriate discipline, that disbarment was or is the appropriate attorney sanction. In this case, when I recommended indefinite suspension based on the demonstrated mitigating factors present. And those factors were that the respondent did fully admit, take responsibility for his conduct, and he did make restitution to his partner of $77,000. And the testimony of his partner, who said in essence that he fully forgiven, that the respondent was a good person. Yes, he committed these offenses, and to this day, while they're not law partners, the respondent leases out from the partner who took the money a law office. And so based on that strong mitigation is why I recommended indefinite suspension.
Counsel, the problem I'm having with your recommendation is consistency with prior cases, where I would suggest the same mitigating circumstances were present, but yet disbarment occurred. Do you think are there other cases with a significant level of theft, and I think we have to look at this as a theft, that you can reference me to where indefinite suspension and not disbarment was the finding of the court? Not the recommendation. I know those cases. I argued those cases. I'm just saying, but the answer always came from this court that it doesn't matter, that when we've got these situations, disbarment's required. Now, can you show me where we've moved away from that?
I'm not able to. I did not research and do any type of comparative analysis as prior cases. And I would agree with you, Your Honor. And again, I recognize that generally disbarment is the appropriate sanction, and the ABA standards say that. But applying the methodology of the ABA standards, you do factor in mitigating factors.
But the reason you do that here and can factor in the mitigating factors and not recommend disbarment is the fact that he doesn't have a conviction. Had he had a conviction, there's really no choice, is there?
I don't, Your Honor, I don't, the fact whether he did or did not have a criminal conviction to me is not, the recommendation doesn't turn on that. I clearly recognize that this court and the ABA standards say that even though there's not a criminal conviction, that if the underlying conduct amounts to a criminal act, which if tried is a conviction, then disbarment is appropriate.
And just so we're clear, Mr. Walczak, the behavior did not stop until he was caught.
That is correct.
The record doesn't reflect that it had stopped before the partner detected
He
it.
was confronted. The partner suspected, based on his end of the year analysis of the cash flow, that there was something amiss, and he retained a forensic accountant who did analysis. And eventually the respondent was confronted. You're correct.
I didn't notice any reference to psychological problems or in this particular record. Am I right? Did I miss something?
No, you're not, Your Honor. There was no evidence introduced at the panel hearing of any type of emotional or psychological issues or any other excuse other than suggestion of maybe his expenses or standard of living got beyond his ability to pay.
Could you remind me what your recommendation is today?
My recommendation today, as was at the panel hearing, is for indefinite suspension.
And how would he ever be taken off indefinite suspension according to your understanding?
Well, before in order for him to petition he would have to petition for a reinstatement, and part of indefinite suspension, he would have to appear before a Rule 219 hearing, and demonstrate that the misconduct that led to his indefinite suspension has been addressed and corrected.
And what's the minimum
And it'll be
period?
up to this court to grant it. Minimum would be 3 years, Your Honor, to petition.
Yes.
If there's no further questions from the court, thank you.
Any further questions of counsel? Thank you, counsel.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. This is a difficult one. I hate being up here on these. The facts in the panel report are dead on, they're accurate. The violations reported by the panel are dead on. All we're here about, and all we were present to argue down below, was mitigation. The most, and I think you do these on a case-by-case basis, this idea that generally if X happens over here, I think is ludicrous. But I'm not a member of the Supreme Court, thankfully. And your job is to make that determination. The most important evidence before the panel and before this court is that his partner, my client's law partner, forgave him for his transgression. And that's important.
And how does that?
Benevolent partner
Pardon?
is a mitigator?
I'm sorry, both you spoke.
Having a benevolent partner is a mitigator for your client?
I think so. Absolutely. I think forgiveness is the most important thing in the world. I think if somebody steals from a trust account, he or she is obviously a thief, and that's wrong. But there are reasons why and mitigating factors as to why that person may have done that. His partner, who called him on it, who said this was wrong, it is mitigating. He said at that panel hearing, I still want to practice law with him. He still shares space with him. They share certain expenses. He refers cases to him. I think it's important. And I think to simply because he has a benevolent partner, that shouldn't count is absolutely wrong. I think that is important. I think forgiveness is important.
Let me
I
ask.
jumped you when I answered Veronda's question.
Okay. We consider theft to be a crime of dishonesty for certain
Absolutely.
matters. And how does a partner's forgiveness translate into a mitigation or obliteration of this dishonesty as it relates to clients in the practice of law? The problem here is with the theft is it displays a characteristic of dishonesty. And how do we protect the public against that characteristic through a partner's forgiveness?
And I agree.
You understand what I'm saying here?
Of course I do. And I agree with everything. I agree with what you're saying. And I hear what you're saying. And I understand it's your duty to say the public is to be protected. We all know that. We deal with that every day in our practice. And I wish I had a simple, articulate answer to tell you. I think it's so important that somebody has forgiven him and wants to give him another chance and says, I trust him, I'll continue to practice law. And he's a better man than me. Because if somebody took from me, I wouldn't even discuss the time of day with that person again. I really admire his partner for saying that. Does it translate, Your Honor? No. But it means something. It's got to mean something, and I can't put a word on it. I wish I could. I can't put a word. And there are no psychological reasons why he did this. There's no emotional reason why he did this. I don't have any excuses. He doesn't have any excuses. He had to know what he was doing. I don't know that there was a why. He said he just started to take it. He started to relieve. That's not a fair statement. He started to redirect money that would have gone into the firm coffers toward him. His partner got suspicious, as my colleague indicated, and called in a forensic accountant. My client paid for the lawyer, paid for the forensic accountant, and also paid that $77,000 that he would have owed towards expenses. He had to borrow from his retirement plan, and he stood up to the plate and did that, and I think he should be admired. I'm not saying you need to forgive him for what he did, but there are ways that people can rehabilitate themselves. And I think it's up to the court, and it's up for us lawyers to say, what do we do to save this person, to allow him to practice again? And I don't know the answer. You know, if you suspend him indefinitely, and the panel says he should give a shot, should be given a shot in 3 or 4 years, or however long it takes, you still have the right to simply say, it's too bad, it's too late. It's absolutely too late.
The same thing happens,
I'm
counsel,
sorry,
the
Jeff,
same thing
Bob.
happens with disbarment. And so it really is what punishment fits, what discipline fits the crime, the offense in this case, because there will always, there always is an option for return.
Except only one lawyer's been returned.
I know.
Under disbarment.
I know. I know it real well.
I know that.
But the point is, I think at this stage of the notion, we have to say, what's the appropriate discipline? And I'm simply looking for consistency. And I don't see it, and I don't agree with the case-by-case thing. I think it's more important that the bar understands on a consistent basis what the discipline is, as opposed to there'll be one set of discipline to a lawyer who's got partners who are forgiving, and another discipline for partners who split on whether they forgive or not, or that there is no partner to forgive. I mean, I can't be a distinction here.
I hear you.
It's got to be the misconduct, and what's the appropriate thing. And I'm just looking for, can you point me anywhere else?
And I wish I could. I didn't want to be
Done
here
this.
today, Justice Biles, because this is an impossible type case to argue, yet you have to be here. I rather would have submitted it on the panel and just let my client, I don't have an answer for you. I wish I had an answer.
What is your request that we do for your...
My instruction by my client, a request by my client, is to ask for a public censure. That was his instructions to me, and I'm obligated to ask you for that, because that was his instruction.
And that's your request today?
That is my request today, per the instructions of my client.
Well,
I'm sorry.
I guess what I'm hearing you saying, maybe I'm misinterpreting, but you seem to be saying that, that he didn't essentially injure any clients, apparently, by this. I mean, not directly, I guess.
That's true.
Is that true?
He didn't injure any clients. That is what I'm saying, Your
And
Honor.
the ABA standards, at least, when deciding what the punishment is appropriate, they place the highest, I guess I would say the highest emphasis on a duty that's violated to a client. And apparently his partner feels comfortable that he's not going to violate duties to his clients, and has forgiven him for
The sins.
the sins, right. And I guess I'm saying maybe that's the only answer that you have, is that at least it's one of degrees in terms of the injury and the duty.
You're absolutely correct, and that's all that I have. I mean, I don't have a good answer, because I agree that this court has said, you commit a criminal offense and you're convicted, you're gone. If the conduct is similar to a criminal offense, which we have here, you've basically said it's the same thing and you're gone. And then we're up here today to argue, and the only thing I could hang my hat on is there must be something good about my person, my client, if his partner is willing to allow him in the office and to give him a chance. There's something good in the sinner. And I know I'm being, as usual, overly dramatic, but I'm trying to answer your questions, and this is a very difficult one for me.
I understand you have instructions from your client on what discipline, but there's also a context for, I mean, if you're a lawyer and a professional and you look at the lay of the land, we ought to know that a published censure doesn't fit this misconduct. So shouldn't I factor that in when I'm considering remorse?
Absolutely.
That this is communicating to me a lack of remorse.
It may be communicating to you, but since I know this client and have been with him for 8-9 months now, I know how he feels, which is not evidence, and I shouldn't be doing that. But he is remorseful. He feels terrible about it. He's discussed it with his partner. And they've come to a meeting and
Did you just say you
Discuss it with
discussed
his
it with his partner?
discussed how he felt.
Discussed.
Oh, I'm sorry.
Okay, thank you.
He has discussed it with his
it
partner.
with his partner.
Thank you.
I apologize. Okay, he discussed it with his partner. That means something. That should mean something to you. But I can tell by your face, it doesn't, Justice Biles, but it should mean something.
It means a lot to me. I mean, believe me, I understand that these things happen, but I'm still stuck on the consistency, but I'm also stuck on the remorse. I mean, it seems to me when you come up here and say, I did this and all I get's a published censure, that says to me that what I did isn't that big a deal, or at least isn't as big a deal as other things. I mean, you can't even reconcile that discipline with this misconduct under anything that I'm aware of in Kansas.
That's fair. I don't disagree with you. I've had the same consternation about this case. With your permission, my client would like to address it.
Before we do that, I
Certainly.
want to go back to an issue that has run throughout cases like this. And there was a suggestion earlier, well, is there anything in the record about psychiatric issues or depression or substance abuse, et cetera? And the answer is no. So we're left with basically, as I understand it, it was, as Justice Johnson pointed out, all that's left is dishonesty
He needed the money for some reason.
for his personal use.
Absolutely true. That's what the evidence is, Mr. Chief Justice. That is the evidence.
And the question then becomes, how do you rehabilitate dishonesty?
Trying criminal cases for 40 years, I've asked myself that a lot. And everybody can be rehabilitated. Unless you're a complete and utter sociopath or psychopath, you can be rehabilitated. Maybe that's my Kennedy liberalism that's coming out here, okay? Somewhere down the road, or at some time during the course of this case, he's had to look himself in the mirror. And he's got to know that what he did was dead on wrong and dishonest, and none of us, as lawyers or human beings, should have done that. I think that's the beginning of the rehabilitative process. And I think having to tell his wife, having to say to his kids, this is what's going to happen to me, having to talk to his partner, I think somebody who takes can be rehabilitated. I'm not a believer. There are very, very few people among us who cannot be rehabilitated. And I think a lawyer who is trained and admits his transgressions can be rehabilitated. That may not be a great answer, but that's all I can come up with as you asked the question.
Are there any criminal charges pending?
No.
Any disposition of any criminal charges?
No, Justice Files, not at all.
Was it ever reported to the police?
I do not know the answer to that question. If I had to guess and speculate, I would say that it was not.
May it please the court. I would like to start by apologizing to the Supreme Court, the Kansas Bar, its fellow lawyers, my spouse, and most of all, to my former partner for what I've done to cause myself to be here today. I have been deceitful and have committed acts for which I am not proud. I am ashamed of what I've done. I did this out of extreme desperation and irrational fear from a failing practice and the resulting financial destruction. I headed down a path that once on I couldn't see a way of getting off and stopping. I fooled myself into thinking the fee checks in question were technically mine in that our firm didn't share revenue between the partners. Instead, fee checks were credited individually but into separate accounts. However, I fully admit that I was deceitful to my partner and there's no valid excuse or justification for what I've done. It was clearly wrong and I can't tell you how sorry I am. To this day, I feel an incredible amount of remorse for what I've done. Remorse for all the people I've hurt. For my former law partner who trusted me, for my spouse who stood beside me for 25 years, to my fellow lawyers and the entire legal profession. I ask the court to forgive me. Since approached with the allegations, I have tried everything in my power to make things right. I have made full restitution to my partner, As that $77,000, that was the number, that was the amount that the accountants determined was what I owed him. I made him whole again. In addition, like Mr. Ambrosio mentioned, I paid all of his related legal and accounting fees. My law partner forgives me. Not only forgives me, he testified at the disciplinary panel, and it's his wish that I continue to practice law with him. I self-reported my violations. I've cooperated fully with the disciplinary investigator and the panel. In the past, I have never been in any other criminal or moral trouble in my entire life. I also wish to note that no client funds were ever misused, converted, dealt with improperly. Since this has taken place, I've had a huge transformation in my life. Things are far different than they were 18 months ago. I live in a world of reality now, whereas before I took my problems, I isolated myself with them, and wouldn't let anybody help me because I wouldn't let them know I had problems. My practice now is self-sufficient and it's growing. I have no problems in meeting those expenses within our shared office arrangement. My spouse now works with me and keeps me grounded. I've even lost 60 pounds during the ordeal. My practice has a large benefit to society as a whole. I am most proud of my work with wartime veterans in helping them obtain their VA aid and attendance benefit. Over the last 24 months, I've helped 52 clients in obtaining nearly $740,000 in VA benefits that they would not be able to receive without my assistance. I'm also proud in helping my clients in painful situations. I basically do estate planning. In helping a 32-year-old divorced client who's dying of brain cancer at the last couple days of his life, set up a trust for his 3-year-old daughter, to basically protect life insurance death benefit, the only benefit he could pass on to his daughter. Helping with a couple in their 60s who has a 24-year-old son with Asperger's syndrome, with bipolar disorder, and a disease called Charcot-Marie Tooth disease, which is a motor neuron disease. Helping that family not only set up the trust to take care of that child for his lifetime, but to also assist in creating a detailed care plan for the child. I do make a difference for my clients and for society. I'm a good man who let himself get on the wrong path and couldn't find a way to get off. I am genuinely sorry, and I feel remorse every day for what I've done. I've tried to do everything humanly possible to rectify the situation, and I've done a good job at that. I've been forgiven by my wife, and most importantly, my law partner, again, whom I still practice with. I am willing to accept whatever punishment the court deems as appropriate. If disbarred or suspended long-term, obviously my practice is probably finished. But if the court finds a place for me to come back, if the court allows me to continue to practice, my practice will be damaged, but it will survive, and I can continue the good works for my clients. The court will not be sorry with what they've done, because I will be a model of turning themselves around, a model of redemption. Nothing like this will ever happen again, not even anything similar, and I am willing to allow any type of oversight or audit of my practice, all at my expense. To the esteemed members of this court, I have asked for public censure because I do want to continue to help my clients and to practice law. It's not a frivolous request. I understand the gravity of what's going on. I'm worthy of being saved. Please allow me that opportunity. Thank you.
Any further remarks from counsel or the respondent? All right, thank you both.
May it please the court, I'll waive rebuttal. I'll answer any questions the court may have.
Any questions of counsel? Seeing none, thank you.
Thank you.
We'll take this matter under advisement. That concludes this morning's docket. Court is now adjourned.